In this case brief, I have Cedar Rapids versus Garret. Facts on the case. Garret F., a minor and student in Cedar Rapids Community School District, requires a wheelchair and is dependent upon a ventilator. He requires assistance in attending to his physical needs during the school day. The school district declined to accept financial responsibility for Garret's services in order for him to be able to attend school. The school district believes it was not legally obligated to provide one-on-one care. An administrative law judge concluded that the Individual with Disabilities Educations Act (IDEA) requires a school district to provide school health services, which are provided by a qualified school nurse or other qualified person, but not medical services, which are limited to services provided by a physician. The district court and the Court of Appeals affirmed, despite arguments from the school district, that such one-on-one care is too costly to be involved to be considered anything related but medical in a nature. Some of the questions and issues of this case. Do schools that receive federal funding under the Individual with Disabilities Education Act have to pay for one-on-one nursing assistance for certain of their students with disabilities? The holdings. In a 7-2 decision, the court held that if the services in question are related to keeping the child with disabilities in school unable to access educational opportunities available to others, IDEA funding school district must provide such services. The court added that although the nature and cost of providing certain IDEA relative services is not determinative on whether their financial burdens must be met, potential financial burdens shall inform any decision governing their provisions. In the present case, the benefits of providing Garret with his needed care outweighed the burdens. And the legal rationales in this case. In the court's views, Congress intended to open the door of public education to qualified students with disabilities and require schools boards to educate those students under the students with who were not disabled whenever possible. Under the IDEA, the court's own precedent and majority insisted that the school board must fund such related services to help guarantee the students, such as Garret, were integrated into the public school. Justice Thomas noted that the IDEA regulations require school boards to provide disabled students with health-related services that school nurses can perform as part of their normal duties. A school nurse could not perform the services Garret needed and continue to perform her normal duties. Instead, Thomas observed, because Garret required continuous one-on-one care throughout the school day, the school board was required to hire an additional employee to attend to his needs.